to walk out and leave. So,
what if the client mandates or a court mandates the person in front of you to take the test, and yet the person in front of you has to pay to take the test?
that's a sticky situation, but it's one, if it's court mandated, they still can choose not to come and do the assessment based off the court's mandate, which, whether that be financial or don't want to for whatever reason, but they're going to have to deal with the consequences.
And same thing with the employer. If they're in trouble and they have to pay for an evaluation because they've been caught on this. I mean, this is the situation. I'm actually, I need to look at my there's the client's rights to review that, because I think it says you have a right to see it. Nobody does, but nobody asks to see this. The paying party has the right, or if we're talking about children, their parent or guardian figure, their legal guardian has the rights. So these are the sections of the ACA Code of Ethics that have to do specifically with testing. So we're going to be competent. We're going in our use and in our interpretation, which means different things for different tests. Some tests having competency really can be reading the manual, going through a very short learning process, and you're ready to go. You are competent to administer, a sentence completion test. Versus if you want to do the ADOS-2, which is an autism diagnostic instrument, it takes a long course that you go to, and then you're supervised for a year by someone who knows how to do this to make sure that you're doing it accurately. So there different tests have different levels that, of competency required. So you just need to be aware of what that is. And you need to be competent in your interpretation side as well. So if it's a level C test, meaning something that is administered by a psychologist, then you're going to want to yield to the psychologist making the interpretations, even if you have read and and understand the situation. It's better to encourage the client to go back to that psychologist for that aspect of the interpretation. Well, it talks about informed consent and the specifics there of making sure that our clients know why they're doing what they're doing and how it's going to be used for their benefit, and what dangers there might be in the assessment process. The release of information is the same as it is with other client data. You might have an employer or client that wants you to release the data to an employer, to a spouse, to another therapist, to a school system. You still have to fill out the release of information and be very careful about how you handle that information and protect it with just the same level of protection you would any client note. So, they have a right to an ethical and accurate diagnosis, that we're going to be culturally sensitive in the way that we choose our tests for them and interpret the tests that we use. We're going to just be thinking through all of the cultural data that goes along with that and biases that go with that. And sometimes it's appropriate not to diagnose. So, let's see. Oh, there we go. I forgot those slides were all there. So, but there's also when tests become obsolete, which generally is a year after the new version comes out, they're considered obsolete. That means you have to quit using it. You have to start using the new version, unless there is a good ethical reason not to use the new version. If the norms become just grossly outdated and they don't update the norms, you still ethically have to make the decision of, I don't think that this is appropriate to use anymore. This is obsolete. The last time this was normed was in the 80s, and you know, it's not the 80s anymore. So, it would be. All right. So let's see. We've kind of hit all that. And just thinking about if you're in a forensic setting, who your obligation is to. So who's the client, who's has a right to the information, who doesn't. Remembering things like lawyers write really scary looking letters that are pretty much meaningless. They're just being threatening and bullies. And it's good for you to have a lawyer that you can go to and say, is this one of those times where they're just being threatening? Or, you know, did I miss the part where it said subpoenaed by a judge? And I have to release my information here. So there can be some really scary letters. So, but thinking about who has the right to the information, who doesn't. Thinking about the timeliness of the evaluations and getting it done so that it helps the client as much as possible. Avoiding those dual relationships where it could be harmful to the client for you to be their evaluator or counselor. So practicing within the limits of your competence is a big one. That'll come up in some sort of way, I'm sure. But you know, again, you know, just make sure that if you're going to buy a test and start using a test, that you get whatever training you need to be competent in administering that test. All right. So I don't think they'll ask you if there's 7 major errors, but there you go. You've got it just in case. But you know, this is just again going through. You know, talking about these things that we've already been talking about in another way. So there's been litigation and laws and things that were created from or that are associated with assessments and testing law. And so some of the big ones, the Civil Rights Act of 1991. This one outlawed discrimination in employment based off of race, color, religion, sex, or national origin. So there's previous versions of the Act you see there, but the latest version, 1991 there, that's something that is likely to show up. ADA, the Americans with Disability Act of 1990, another really big one, banning discrimination on employment and access to public services. And transportation, telecommunications, all of that based off both physical and mental disabilities there. So you can't discriminate if based off of mental disability or physical disability. These are all things that we just kind of know, but this is the act associated with it. IDEA, 2004. This is the one that gives students and the right to a fair and appropriate education. If you have some sort of disability, the school system has to work with you to provide you an education in such a way that it levels that playing ground, that they that playing field, that makes it so that you get that appropriate education. So when you're working with clients that have severe attention difficulties, you know, you hear about things like extended time or testing in a less distracting environment. That's because of this. So, all right. And each state has to have a comprehensive system to identify this. So another thing that our clients sometimes don't know is that whether your kid's in public school or private school, it doesn't matter. If you are a resident in the state of Georgia and you are paying taxes, well, even if you're not paying your taxes, if you can send your kid to the local public school that you would be districted for, and they can be evaluated within the school system to help them determine whether or not accommodations would be appropriate. So if you have a private school parent and they're saying, well, yeah, but my kid doesn't go to the public school still has to offer that to them for free. It's part of your tax dollars. The downside to that is that the system is incredibly slow because they are overworked and understaffed, and so it takes a very long time. Most recently, folks have been talking to me that it was going to take a year for their kid to be fully evaluated, so they wind up coming and paying a private psychologist. So.
In Tennessee,
Uh-huh.
because it was recent, because we use the Tennessee law is a little different.
Mm-hmm.
So the different states handle that different, but because
Okay.
mine were in private schools,
Uh-huh.
they had a moratorium on testing kids in private.
So they wouldn't do it for.
And they wouldn't do it, and I issued an appeal.
Yeah.
Because I said they're coming out based on financial issues, and they were, what they were telling us was they're gonna put them in regular classrooms, and
Mhm.
then they would have to be here for 6 months and then get a referral.
Right.
But it took, and encouraging your clients to fill it, because we got a waiver based on the appeal. There was a moratorium on testing because of finances and needs,
Yeah.
that nobody in the private school system, you know, you pay the taxes.
Right.
That's just that knowledge that you can encourage and appeal for
Exactly.
your clients is really helpful, because we appealed it just because opportunity. We're able to
And
get what we needed.
and there are client advocates. Their job is, they're lawyers basically that go and fight and make appeals and things like that. That is their entire job. Is
Because we offered to pay for the private, and the school system told us they wouldn't accept that it has to be their own in order to receive the services. So just being an advocate for your client.
Yeah.
Looking to appealing and not.
It's unlikely you would run into that situation in Georgia, but yeah, that's good to know that there's a difference there. Yeah, thank you. Oh, I didn't talk about FERPA. FERPA, this is saying that every parent and student have the right to inspect their school records, to know how things are going, what their grades are. So if you're under the age of 18, that means the parent can walk into the school and demand your report card and demand to know how things are going in the school, which is good. This is to encourage accountability. If you're over the age of 18, it gives you, the adult, the right to say, hey parents, you don't have the right to my grades anymore.
Yeah.
But the idea is we're trying to protect student privacy while also holding school systems accountable. So HIPAA, the Health Insurance Portability and Accountability Act. These are a group of standards that have been created to help protect patient information so that diagnoses and identifying information and things like that wouldn't be shared. A patient's information would not be shared without the client's knowledge, would not be shared in an inappropriate, unethical manner. So this is a way that a group of procedures to help us keep that information as protected as we can, and safeguarding the client's information. It goes down to all kinds of specifics, like the way that we keep information in our files themselves, the file cabinets, the locks on the door, having 2 locked doors. If you use, some sort of digital media, not putting things like birth dates and social security numbers and diagnosis and names and things like that out there. So we survived. That was, I don't know, those of you, some of you are old enough to know the old Micro Machines commercials where the guy talks a million miles a minute. So it's kind of what that felt like for me. There's a ton of information here. Again, I encourage you, if there's something that you still have a question about, you can ask me now. You can ask me afterwards. You can email me. These are some of the things that Dr. McGee and I think are things that are likely to show up on an NCE kind of CPCE sort of test, which is why they were included in this. I wouldn't call this exhaustive.
I would call it exhausting.
It was exhausting, I will give you that. It's absolutely exhausting. When it comes to things like names of people, the father of, the first of kind of things, those are things that are likely to show up. In my experience in taking these kinds of tests is it hasn't been a ton of that, but there's always some of that. When you get to the individual instruments and things like that, they're more likely to expect you to recognize something is in the family of intelligence tests, like a Wechsler Intelligence Scale for Children is an intelligence test, or the Rorschach is associated with personality testing and is a projective measure. You know, if they got that specific, that's how they're not going to ask you what the subtests of the WISC-4 are compared to the WISC-5. That's not something they're likely to get into that kind of minutia. They are T-scores and Z-scores and all that good stuff. There's likely to be something associated with that. But remember, this is a ton of information. There's not enough questions on the test to cover all of this. But historically, students in this program have done well on the items associated with this content area, is the feedback that I've been given. And ethics, just to kind of help you feel a little less stressed, because I know that's another one that has a lot of detail. Just go through, read through the stuff, the things that I was talking about today. If it just didn't ring bells, read through that stuff again, contact me. I'm, again, CAllen at Richmont. Make sure you don't put the mail in there, because then it goes to Chris, who's a student, and that one, So CAllen at Richmont. I'm happy to answer any of those. Let's see. You'll notice I didn't really get into a lot of test naming, because that's probably not as important for you guys as because those constantly change. So licensure exams recognize that, and so knowing what is current in 2017 isn't really that pertinent for 4 years from now. So just be thinking about those kinds of things as you study, is the big concepts and all of that. What questions? I'm sure that was all easy, you remember it all, but humor me. Really? Not a line? Everybody's like, we're done. We actually are time-wise, I think. I think we're supposed to be taking a break here. So you've made it through all the content area. Congratulations. You will do awesome on the exam. Sleep. Don't be one of those people cramming minutes before. We know from research that doesn't work. So sleep, have some coffee that morning, relax, have a good time taking it or something. Yeah. And you're being prayed for by all of your professors. So, all right.
Thank you.
Thank you, guys.